You believe your doctor screwed up big time, causing you significant harm and injury, and now you want to sue your doctor. So you find the best attorney you can, who then goes ahead and hires a medical expert who reviews all of your records and now gives your attorney a conclusion about whether or not you have a valid case. If the medical expert tells your attorney that you have a valid case, but did not review all of your medical records necessary to make an educated decision, how is that going to affect you and your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You want to know how it's going to affect your case? Tremendously! It's going to have a huge impact. Why? In these types of medical malpractice cases, we are required to have a qualified medical expert review and evaluate your particular case before we are ever permitted to actually start a lawsuit on your behalf. A medical expert has to review all of your medical records, all of the relevant medical records, in order to determine, number one, whether your doctor was careless, whether or not he violated the basic standards of medical care. Then the expert has to determine that if the answer is yes, was that a cause of your injury? It doesn't have to be the cause, it only has to be a cause. And then the expert has to look and see how bad your injuries are. Are they significant? Are they permanent? Only if all three of those things are present are we then permitted to go ahead and say, yes, you have a valid basis for a case. Now, and only now, are we permitted to go forward with a lawsuit on your behalf. So now, what happens though if the medical records that we provide to the expert are insufficient? What if we cannot obtain all of your necessary medical records? Can the expert go ahead and give us a valid answer to the question about whether or not you actually have a good case? The answer is no, he cannot. He can't make an educated decision. He can't make a valid decision. And here's why. If we provide the expert with only certain pieces of your medical record, now there are gaps in the actual medical records, the evidence that we will need to go ahead and show that we are more likely right than wrong, that what we are claiming is true, that your doctor was careless. And now, what happens at trial? The first thing that will happen during cross-examination is the defense lawyer, the lawyer who represents the doctor you have sued, will get up during cross-examination and ask the doctor what records he has reviewed. Doctor, can you tell me what records you reviewed in order to reach your conclusions? And now the doctor is going to give a list of those records he reviewed in order to determine that you have a valid case. And if, in fact, certain records are missing or records have not been reviewed, now the defense lawyer is going to cross-examine this doctor extensively to find out why. Why not? Well, Mr. Oginski didn't provide me with those records, and there was nothing to indicate that I needed those records. Okay, so now not only will the attorney identify which records the doctor did not review, but then he's going to pull out those records and begin asking this expert questions. Doctor, I want you to assume that these records from Dr. Jones's office indicate that on this day the patient complained of the following things. Do you think that would be important for you as an expert reviewing this to know? Yes, it would. And if you had known that at the time that you were originally reviewing and evaluating this case, would you agree that your opinion would be different than it is right now? And the expert is going to have to turn around and say, yes, it would be different. And how would it be different, doctor? Well, in that instance, there wouldn't be any malpractice. Oh my God, are you kidding me? You've now spent 2 or 3 years litigating your case based upon the say-so of this medical expert, all because he went ahead and concluded that you had a case based on the records that he was provided. But if in fact he had all of your records, all of the necessary records, then maybe his opinion would have changed. And the defense attorney is going to go through each and every record that the doctor has not reviewed and highlight exactly which facts are favorable to him, and ask the doctor point blank, doctor, if you had this information at the very beginning, would you agree that your opinion, your conclusions would be different than they are today? And he's going to say yes. And in that instance, your case is basically over. So why do I share this with you? I share this with you because it is so important to send our expert all of the necessary medical records to give us a thorough, detailed conclusion about exactly what went on with your medical care and treatment. The doctor's opinion is only as good as the records we provide, so that if he is missing certain critical information, now his opinions, his conclusions are deficient, And those deficiencies are going to be highlighted and brought out at the time of trial. You know, I do realize you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit and are thinking about bringing a case, what I invite you to do is pick up the phone and call me. You know I answer questions just like yours, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.